So without further ado, let's start talking about, is your marketing department GDPR ready? First of all, we'll cover off a quick piece of housekeeping. So we're recording this webinar, so if you've got colleagues who weren't able to make it today or anything like that, then do please encourage them to view the video. It'll be available on YouTube or from the Fifth Step website, as you can see there, and indeed we turn them into podcasts as well. So do please encourage people to sign up for them. You will receive an email in probably about a couple of days' time letting you know the details of where to download or where to access the podcast and the video. This is what we're intending to do today. We're intending to take you through what the headline and scope of GDPR is. There's a lot of discussion about GDPR at the moment, so I will cover the headlines and the broad scope on the assumption that many people will already know what GDPR is. If anyone's got any questions I can either answer during the course of the presentation, though, then ask away, and if they're very detailed, then perhaps I'll take them offline. So we're going to cover the headlines and scope, and we're going to help you understand some of the terminology that's used within GDPR, and we're going to help you understand the definition of private and sensitive data as it's defined in the GDPR, and we're going to understand the rights of the data subjects, very, very important aspects, and the impact of GDPR on common marketing processes. So the key aspects that you guys are going to want to know about today, we're going to cover off some of the key ones. I'm sure there's going to be many more that you guys are going to have questions about. So, as I said, please do ask those as we go through. And we're going to talk about some of the consequences of a data breach. Okay, and then we're going to talk about how you can get on the path to compliance and what you need to do to actually get things in motion. Okay, so let's keep cracking on. So, the headlines for GDPR, and I've just included a couple here. These really sum up what many people are considering to be the key parts of GDPR. So GDPR applies to companies irrespective of their geographic location, so long as they are collecting, storing, or otherwise processing personal or sensitive personal information about EU residents. Okay. Key there is that you're processing data about EU residents. It's not about EU citizens, and if you are an organisation that's based in the US, and I know we have a number of people from the US watching today, if you're an organisation that's based in the US but you have European clients and you're storing their data, then you need to be considering that too, or you will be part of the GDPR as well. The fines for non-compliance, now these are the scary numbers that you'll be seeing in all of the media, but the fines for non-compliance can be as high as 20 million euros, which is about 17 million pounds, or about 22 million dollars at the moment, or 4% of annual global turnover. So 4% of annual global turnover, that's going to hurt even the larger organisations, the Googles and the Facebooks of the world, let alone some of the larger insurers would start to fall into that category. And it's the higher of those two numbers, so it's not as if you have a choice between the two, it's always the higher of those two numbers. The GDPR will apply to UK-based companies irrespective of Brexit. It's an important aspect. The UK government, it's an important aspect that someone has just said that they perhaps can't see the screen. I'm hoping that I've shared it and reshared it, so I'm hoping that you can now see that. If anyone's still having difficulties, do please just ping me in the question area there, and I'll make sure that that we do something about that. Great stuff. Someone's confirmed they can see it, so that's good news. Okay, I will carry on. GDPR will be enforced from May 2018. So, in fact, it's the 25th of May 2018. So, the Information Commissioner's Office, that's the Data Protection Authority here in the UK, has stressed that it's going to be a softer landing. And now I'm taking that to mean that they're not going to be being strict in the first couple of months, but bearing in mind that they've been talking about GDPR for the last 2 years. I'm not sure how soft a soft landing that's going to be, or indeed how long that soft landing is going to last. So the target is for everyone to be GDPR compliant from May the 25th, 2018. A glossary of terms. Now, we're going to make these slides available after the event, so I'm going to talk about some of the key ones here, but you'll have this, you can download a copy of the slides if you think this slide in particular is useful to you. You can download that after the event and understand exactly what these are. These are, of course, only a summary. The GDPR defines them with a lot more detail, but this glossary contains a really good summary and something that's useful to you, I'm sure. Key aspects or key phrases that we'll talk about. Let's talk about personal data, first of all, because it is at the very heart of what the GDPR is about. So it's information relating to a named or otherwise identifiable individual. Okay, absolutely key phrase there, identifiable individual. And this includes any expressions of opinion about the individual and any indications of the intentions of the data controller or other person in respect of that individual. So that could include, in marketing terms, that could include campaigns where you're segmenting individuals into campaign groups. If you're separating high net worth individuals, for example, so you're taking an opinion on people. That information, not only their personal information, their name, their address, their email address, etc., is considered personal information, but also that opinion of them that they are a high net worth individual can also be considered to be personal information. IP addresses are also personal information, so I include this information for marketeers because very often marketeers are including analytics, Google Analytics and other types of analytics on websites these days to understand where people are coming from. So you're collecting IP addresses and you're also recording cookies. That kind of information is considered to be personal information under the terms of the GDPR. Okay, that's a change from the Data Protection Act, or a clarification, should I say, from the Data Protection Act, which obviously was invented or came into power long before the internet was really a big thing, and certainly long before cookies were a popular thing. I'm also going to talk about now the data controller. It's another key phrase. So the data controller is the person, company or organisation who determines the purpose and manner of processing of personal data. In other words, the body responsible for the data. So in most instances, for most of the people who are registered on this webinar today, it's going to be your employer. It's going to be your employer who's actually the data controller, and as an employee of that organisation, you are entitled to use the data for the purpose for which it was collected. But as a data controller, you're specifying, or the organisation is specifying, why the data is being collected. Now, you can have one or more purposes for collection, but marketing has to be specified as one of the reasons. You can't say we're collecting this data for the purpose of providing a service and then decide that you're going to use it for marketing as well. Okay, that's called a change of use, and you have to make sure that the data subjects are signed up to that change of use. And the last one I'm going to talk about on this slide is consent. Consent has always been important for data privacy, but the GDPR enforces this even more, and consent has to be freely given and specific. Okay, so that means that you can't have pre-filled tick boxes anymore, and I will cover some of the conflicts that might raise in a further slide. But you can't have the pre-filled tick boxes, and you can't just say, oh, we're taking your data to use it for whatever we want to use it for. You have to be very specific in terms of the purpose. Okay, but as I say there in the last sentence, consent should be positive consent, i.e. opt-in. So let's talk a little bit more about personal data, just from the high level, and then I'll talk about it from a marketing perspective. Okay, in all of these slides, there's 2 or 3 in this part of the presentation. I'll talk about and I'll reference the specific articles. That means that if you feel that you need to go and do further research in this area, you're armed with the right information to get you started, and you're not going to have to read the whole of the GDPR documentation to understand what I'm talking about here, or to do your further research. So, as I said, personal data is any information relating to an identified or identifiable natural person, and they're called the data subject. Now, for marketing purposes, it's good to note that this includes names, physical addresses, email addresses, social media addresses are also identifiable information, and cookies, as I've already mentioned, and of course the dreaded IP addresses. So whilst it's less important for most marketing departments, you should take notice of the fact that GDPR states that it's any information. So this can include physical documents, not just computer-based or digital records. As I say, that's more important for some HR departments and things, but it's important to understand that that you're not off the hook if you're storing everything on paper. Personal sensitive data. Here we're talking about information that is that identifies more sensitive information about an individual, about the data subject. Now, these are things, I classify these things as things that people have been persecuted for, or are particularly personal to a person. So their genetic information, biometric data, their sex life or sexual orientation, their race, ethnic origins, religious or philosophical beliefs, all those kind of things. So if your organisation, again, to put it into marketing campaign, or marketing terms, if you're running a marketing campaign that talks about, it's a union members campaign, then you should understand that you are actually creating sensitive personal data there by identifying the recipients of that campaign or participants in that campaign as union members. So something to take note of. And you'll see there I've put a little yellow note there to talk about age restrictions. Now, many of the people on the webinar and probably listening to this as podcasts as well, perhaps won't be dealing a lot with age-restricted data, but you should understand that the GDPR considers a person to be a child up to, actually it varies slightly between countries, but really certainly by the time they are 16, but in most regions it will be when they are 13 years old. Okay, so up until the age of 13, they are certainly considered a child, and it may be as much as 16. So if you are offering products or services that are intended for or are going to be consumed by minors, then you have to take account of that. You have to take particular care of the data, and you also have to have parental consent or guardian's consent to use the data as well. I mentioned earlier on about the importance of the purpose, the data collection purpose. Within GDPR, you have to really be specific about what you're collecting the data for. So you're going to collect it for the provision of a service. If you're going to collect the data and use it for marketing, then you have to say that and make that clear too. And what's more, you have to be able to allow people to opt out of certain aspects. So marketing would be one of those areas where people would be given and should be given the opportunity to opt out of marketing or receiving additional information about your products. It's absolutely key. The data collection purpose states why the data is being collected, how it's going to be used, and how long it's kept for too. And you should also include any information about third parties who are going to be given access to the data, and you must include the details of your data protection officer. We'll cover, I think, the details of what a data protection officer is in a little bit more detail in a little while. But the key aspect there is that you need to have a contact point, and this needs to be telephone and email address type contact point, so that a data subject can inquire about how their data is being used and indeed enforce the rights of the data subject. And we'll touch on those right now. I'll just draw out some of the key ones of these. Not all of these apply to in a marketing setting or in most marketing settings that I'm certainly that I'm familiar with, but I'll touch on some of the key rights here. The first one, the right to be informed, is absolutely critical, and it's something that marketing departments must be aware of and must ensure that the data subjects, when you're sending out newsletters or you're obtaining people's data in order to market to them, that they understand the data purpose, exactly the aspects that we were talking about previously. So they're making a fully informed decision to opt in and to provide their data, and they know what they're providing it for. The right of access, I'll just cover that very quickly because it's not too marketing orientated, but the right of access means that the data subject has the right to request to know what personal data your organisation is holding on them and how you're using it. The right to rectification may be, and it's actually quite an interesting aspect from a marketeer's perspective. You have to correct the data and maintain the data when it's identified as being incorrect. So if someone comes to you and says, I want a copy of my data, and when you provide that data, they say, oh, well, my address is 3 years out of date, here's my new address. You must update that. You must keep that information updated. So the data subject has a right to ensure that their data is correct. The right to erasure, this is usually the point where I make a joke about other 80s bands, 1980s bands are available. But the right to erasure means that the data subject has the right to request that their data be deleted. So think about the consequences of that from a marketing perspective. May mean that, that someone is going to request that their information is deleted, that your campaign numbers go down by 1 or 2 or whatever as people request to be removed from marketing campaigns, or just ask your organisation to just stop processing their data. The right to restrict processing can have a marketing aspect. It means that a data subject can ask for their data not to be processed in a particular way. That could include marketing. Right to data portability, not really a marketing issue, but it means that people can ask for a copy of their personal data in a machine-readable form. So in a way that they can perhaps go to one of these websites, insurance websites, where they can, something like Compare the Market or something like that, where they can go there and put in their details and decide that they are going to move insurer after all. And then they can click a button that says, I'm asking for a copy of my data so that I can provide it to my new insurance company. The right to object is really combined with the right to restrict processing. The data subject has the right to say, I don't want my data to be processed in this way, and to either ask for the data to be erased ultimately, or just to restrict the way that the data is used. So again, it may be that someone requests to be removed from a marketing list or not to be included in certain types of marketing. Again, not a marketing one, but the right to manual processing means that a data subject can ask for an individual assessment of their case. So where someone's refused for a mortgage, for example, because the computer said no, it could be that they actually asked for a human assessment of their case and of their mortgage application. So marketing is different in the terms of GDPR. I won't be receiving any shouts of disagreement from the audience here that marketing is different, but it's different in terms of the Data Protection Act, because Recital 70 states, and I'll read it out for the podcast listeners, but it states that where personal data are processed for the purposes of direct marketing, and specifically, the data subject should have the right to object to such processing, including objecting to profiling to the extent that it's related to such marketing, direct marketing, and whether with regard to initial or further processing. At any time and free of charge, they should be able to object to that, and the right should be explicitly brought to the attention of the data subject, presented clearly and separate from any other information. So as part of your data purpose, you need to be drawing out the fact that they can object at any point in time, and they can actually assert any of the rights of the data subject. Okay, so recital 70 is enacted in Article 21, the right to object. So that's where it all comes together around marketing. Now, marketing is the only function, the only business function that's actually mentioned explicitly within the GDPR. So you can understand how seriously the regulators are going to consider this going forward, and indeed why it's important that you as marketeers and as marketing departments understand exactly what the rights are and how to enact them and how to keep on the right side of the law and of the regulation. Some of you will be familiar, undoubtedly, with the Privacy and Electronics Communications Regulation, PECR, and there are a number of cases, and I've seen on a number of forums where people are talking about contradictions or perceived contradictions in PECR and the GDPR. I'll give one example here where the PECR allows tick boxes to be pre-ticked. So you can say, "Oh, I opt in to receive marketing." The PECR allows users or allows those tick boxes to be pre-ticked for the user, whereas the GDPR does not permit pre-ticked tick boxes for such things. So it has to be an active consent, as I said earlier on. So at first glance, this looks as if the GDPR and the PECR are actually in conflict with one another, but the PECR is not saying you must pre-tick, it's saying that it's permitted. We're not recommending one way or another, but it is permitted to do so. Whereas the GDPR is explicitly saying where you're seeking consent, you should not be pre-ticking the tick boxes. So I understand how people understand that as a conflict, but one is a guideline and saying it's okay to do so. The other is saying things have moved on, and actually it's not okay to do so now. Now, there are going to be some changes to the PECR over time. The original time frame saw these being changed and coming into force around about the same time as the GDPR. The reality is, though, that's just not happening. So for the time being, there will still be those perceptions of conflict or differences. Ultimately, though, the GDPR is likely to win out in certainly in cases like this, where it's explicitly saying that you shouldn't do something. But as marketing departments and as marketeers, you must be conscious of all the regulation that you need to adhere to, depending on the type of marketing and your approach to that marketing that you're undertaking. The soft opt-in rule is no more. So I've sort of covered this a little bit in some of the previous things I've said, but under the Data Protection Act, it was acceptable to consider a data subject as consenting to receive marketing information if they bought a service that was similar to the one that you wanted to market to them about. That's no longer permissible under GDPR. So if you have been making use of the soft opt-in rule, so if you've been selling, if your company has been selling people a product and has then been marketing the upgrade to that product to them without seeking explicit consent from the data subject, you need to be changing those processes and thinking about those processes right now so that you've got an active consent. And what's more, where you are doing that, and you have been doing that in the past, you need to be updating your database to ensure that you've got active consent, going forward, that you're not relying on the soft opt-in rule any longer. That, I would say, is something that many organisations and marketeers are going to be considering and need to think about think quite a lot about, and I'll cover some aspects, some follow-on aspects of that in the next slide, I think. There we go. Mailing lists and contact databases. Most organisations have mailing lists and contact lists. Many of them have perhaps not been 100% legal historically. I'm not casting aspersions about any organisations or indeed sectors. I think it's just been a general aspect of misunderstanding of what you're allowed to do and what you're not allowed to do. A couple of organisations recently, Flybe and Honda, were both fined for misusing their mailing lists. The key aspect here is that they were actually fined even though they were misusing their mailing lists in the quest for becoming GDPR compliant, which perhaps seems a little bit galling, or seemed a little bit galling to those organisations. But what they were actually doing is mailing people who had opted out of receiving emails and asking them to update their information and change any of their marketing preferences by visiting this website. A number of people complained to the Information Commissioner's Office, who ultimately levied these fines. Now, Honda receiving a £13,000 fine, obviously I'm sure whilst Honda weren't happy about it, it's obviously not a massive fine for an organisation the size of Honda, but it does underline the fact that the Information Commissioner's Office takes it very seriously, the proper use of mailing lists and ensuring that people have provided consent and opted in, have provided active opt-in, certainly in the post-GDPR world. So what should you do next? This little chevron diagram here explains you should first of all establish what data you have. If you don't have it in a single database, then that's certainly something that you should look at. Depending on the size of your organisation, obviously it might be a database, it might be a CRM system, it might be a big spreadsheet. But establish what data you have. Ideally, centralise that so you can establish controls around it in a sensible way. Establish what data you can use. Might even be better to completely segregate the data that you can use from that you can't, rather than just in a database having a field or a flag, or in a spreadsheet having a column that you usually filter out from. What you don't want to do is have some junior member of staff, for example, come along and send an email to everyone on that list, ignoring the opt-out and opt-in flags, and all of a sudden your organisation is finding itself in the same company as Flybe and Honda. You also need to establish if and how you can obtain consent. So if people have actively opted out of receiving emails from you, then the chances are you're not going to be able to persuade them otherwise, unless they come and buy another product, or you get another opportunity to ask them to opt in from your or to your marketing. Don't go out and try to actively canvass those people if they've opted out. That's the direction of where fines fines from the ICO lay. Other expressions of non-consent. It's important to take these into account. There are many types of lists that are opt-out lists in different countries. In the UK, for example, the Telephone Preference Service, TPS, and the Mail Preference Service, MPS, are two of the most common. They obviously allow people to express their preferences to receive advertising by telephone and by mail. There isn't the same list for email at this point in time, although you've got to think that's not going to be too far away. With the GDPR just around the corner, I could certainly see that coming along. So make sure in any of your mailing campaigns or telephone campaigns that you're understanding which methods you can actually contact your existing clients or your prospects or your mailing list, which methods they've signed into. Under the GDPR, you need to understand where your data has come from. Now, this means that if you're buying lists of data, then you need to be able to identify the source there. If it's coming from within the organisation or as part of if they're active clients, then you need to be able to understand that as well. So the reason and rationale for that is if permission were removed, so if the owner of the original list that you bought removes the permission for you to be able to use that list, or has everyone opts out of that list, then you need to be able to identify that information and remove it from your campaigns to ensure that you remain compliant. Many CRM systems and databases and obviously spreadsheets will not contain that capability right at the moment. So it may mean that you have to add extra fields to your CRM or to your database or indeed your spreadsheet to be able to capture that information. And there may be a task to actually go back and try and establish where that original data came from. Another important point around where the data came from, you have to be able to record and document people's consent. So it's no use just having a tick box on your website and that people have to tick in order to proceed. You have to be able to record and evidence they've actually ticked that box and wish to proceed. And you have to be able to evidence that in a way that if you did have an investigation from a data protection authority, the Information Commissioner's Office in the UK, for example, that you could actually say, oh yeah, at 5 PM on the 1st of January, Bob Smith ticked the consent form. Getting atomic with consent options, I'm not up for any awards for writing headlines, but I do think that's one of my better ones. I'll leave you guys to be the judge of that. But you have to be able to balance consent with real marketing preferences. Now, we've probably all seen on websites where they'll ask whether it's okay to contact you by email or by post or by SMS or by other methods and mechanisms. The reasons that that we all probably understand why they do that is so that if you don't want to be contacted by SMS or telephone, for example, that if you're only giving the one option, then people will opt out of all options of contact. Whereas you may be able to refine their preferences slightly and move them more into their comfort zone. They may be okay with receiving updates about similar products by email, but they don't want people phoning them at 8 PM at night asking them whether they're happy with their current product and whether they perhaps want to upgrade or whether they want to buy a different insurance policy or whatever it may be. So what you can do here is offer real choice, and that's where the going to the atomic level can be useful, but you've got to really balance that. No one wants to see a sea of tick boxes in front of them at the end of a personal data submission, some kind of where you're asking for people's details. No one wants to see that sea, but you might perhaps want to get down to a level of granularity where you're asking them, can we use your data? Can we send you emails? Can we send you text messages? Can we send you our newsletter? Because again, people will opt in for certain things. So find the appropriate level for your audience. An interesting aspect around GDPR is it's increasing people's understanding of the data that they have within the organisation. A big part of what many organisations are going through at the moment is data mapping exercises, so that they understand exactly what data they've got and how they can use it and things like that. So one of the recommendations that I've got, and we're talking to a number of people about this, marketeers and marketing departments about this, but how to get closer to the Chief Information Officer or the information management team, whoever's ultimately responsible for the data within your organisation. Get closer to them and help them help you in terms of the amount of information and data that you can use and how you can use it, because there is a wealth in many organisations. There's a wealth of underused and underutilised information, some of which you might be able to use for trending purposes, as I pointed out there. Not just direct marketing uses. You may be able to identify how how you send 3 newsletters before a sale, or your sales always go up after a newsletter has gone out, or something like that. If you can identify those trends, then well may be that there's good marketing and data and further uses you can put that data to, and legitimately too. So get some additional benefit out of the GDPR. Help or get your CIO or the information management team to work more closely with the marketing team to help you understand what data is in the organisation and how you can use it. Ultimately, we're all aware that data breaches occur. There's been many high-profile data breaches recently. Equifax, for example, was not only one of the larger ones, not the biggest, unfortunately, but in terms of the type of data that was stolen, it was very it certainly fell into the category of personal data, and it also fell into the category of sensitive and financial information as well. Everything you would need essentially to create a new identity was stolen by the hackers who breached Equifax. Now, marketing departments don't tend to carry that sensitivity of data, but if a data breach should occur, then there's the other side of marketing and and PR that comes into play. And obviously, I know that we have some PR companies who are listening today. The opportunities there for you guys to be involved and help organisations, ideally before they have a breach, but certainly as part of the breach response, is something that's interesting and something that more organisations are looking at, because you need to be prepared. You need to be able to do a good job should a breach occur. Now, GDPR places a lot of additional pressure on organisations. You only have 72 hours. So I'll repeat that number again: 72 hours to notify the Information Commissioner's Office of a breach. Okay. Now, there are sizes and scale of breach, and there are some guidelines around that. So if you have a breach of 10 people and it's name, address, and email address, the chances are that you won't have to notify the Information Commissioner's Office, but you may decide it's prudent and the right thing to do to notify the data subjects. Okay. But if you have a large breach, you're going to be notifying the Information Commissioner's Office, and you're also going to be probably, in all likelihood, notifying the data subjects. So understanding how you can do that, how you can do that effectively and efficiently, comes down to a combination of PR and marketing. And in the post-breach environment, marketing is going to be important to help the organisation recover from any reputational damage that they may have suffered as a result of the breach. You might want to think as well if there are other impacts that are specific to your organisation. Is your organisation one that markets itself on a high degree of trust? The impact, the reputational damage to such an organisation of a data breach is obviously going to be higher to an organisation who is perhaps not a terribly well trusted organisation in the market. So what should marketing departments do next? In keeping to the script of using chevrons to indicate a process in motion, we've got some nice coloured chevrons here that indicate some of the key things. So first and foremost, ensure you've got consent to continue using your existing data sources. Okay, if you're in any doubt about that, really make sure that you've got it covered off by the time that GDPR goes live. You don't want to be left, with a vastly reduced data set just because you haven't had time to enhance it or improve the data quality or get consent before the GDPR comes in place. Understand the types of data that you've got, so participate in the data categorization and data mapping exercises that other parts of your organisation are participating in. Understand and again participate in the creation of data purposes and make sure that they're in place. Make sure your marketing systems have the ability to comply with the GDPR. All the things about logging consent, understanding and documenting where data came from, which list it came from. Put in place and again participate in the creation of a data incident response plan. This is really mandated by the GDPR because you've only got 72 hours to respond. You can no longer say, well, that's okay. If we should get hit, then we'll decide what we're going to do. Should that happen, you're going to have so little time to actually respond now. With only having 72 hours, then you're going to have to have a predetermined plan that you can play to. And finally, be able to demonstrate compliance. So be able to demonstrate that you're doing the right things, that you are that you're taking people off of the marketing lists when they request it, that you're able to produce information about who is on the marketing list should a data subject issue a subject access request, which basically is their right to gain access to the data. So make sure that you're compliant in all of those ways. One of the next steps, or if you need help in the next steps, Fifth Step has what we call the Fifth Step Quick Start GDPR assessment, and that can help you get on the right track and help you gain some of the benefits that we've spoken about there. And I'll let you read some of those details. I've seen a couple of questions come in. If anyone's got any further questions, then please do ask them now, because we're just about the point when we're going to start moving into questions. So I can see a couple of questions, as I said. Let's see who we've got here. Thank you very much for participating in this, mate. Let's see if I can extend those out. Okay. Okay. So question here from Tim. Can we exclude any non-EU contacts from our e-privacy compliance activities, e.g. US, Asian, Australian clients who live and work in those territories? Would they need to have non-EU operations or offices? Okay, Tim. All comes down to where you're doing the data processing. These processes and approaches have to be in place for EU residents. Okay. If you are processing the data within Europe, though, actually there's not really a restriction. You have to, the GDPR says it has to be in place for EU residents, but then you have to treat all personal data this way. So even if they're Australian residents and you're processing the data in the UK, for example, then you would still have to adhere to these rules. So you'd have to process it in the same way. Now, one of the things that you should consider in that, though, if you've got systems that are operating in other locations, so if you've got a CRM system, for example, that's based in Australia, and you're just having all of your Australian target or prospects or marketing lists contained on that, then that would be absolutely fine. Okay, and likewise for the other territories that you're talking about there. But do be aware, GDPR isn't the only data protection regulation. Australia has its own data protection regulation. There are countries in Asia, such as the Philippines has data protection, Singapore has data protection, and there are others that mean you'd have to adhere to their data protection regulation too. Okay, so just have a think about it from that perspective. And Tim, I know you dropped me a mail previously asking me this this question, or to ensure that we covered it in the webinar. If I've not answered that fully enough, then do drop me a mail. I'm happy to have a coffee and go into a little bit more detail with you if that helps. Okay, oh, more questions coming through. Excellent news. Okay, so another question here. For existing clients, can we continue to share relevant messages by email by using legitimate interest without the need for opt-in? No, unfortunately you can't. That's the soft opt-in that I mentioned earlier on. You need to make sure that you've got active consent now. Okay, another, yeah, even though there's no soft opt-in. Yeah, sorry, no, you can't do that. Okay, is there an automated way of sorry, let me understand that question. Oh yeah, is there a way of automating GDPR processes with software, for example? Yes, there are some processes that you can automate. That's a very good question. So things like data retention. So if you're only allowed to market to these people whilst they're subscribed, once they've unsubscribed, you're going to delete their data. Obviously, you can have a field that's within your database or your CRM, which is unsubscribe, and have an automated process that goes through and deletes any users, any data subjects that tick that box. So you could do those kind of things. Okay, so as a compliment at the beginning, explained very well. Need to track the origin of the data. What are my obligations if I use external supply, e.g. MailChimp or Rhizo assessment provider? How can I be sure they delete the data? This is an excellent question, and actually I've spent most of the morning with a client going through some similar challenges about third-party providers and service providers. Under the GDPR, you remain responsible. Okay, so you can outsource the function, but you cannot outsource the responsibility. So the answer to your question is you need to be responsible for vetting and ensuring that your external third parties are in compliance and adherence with the Data Protection Act. With the GDPR, with the Data Protection Act as well before the GDPR. But under the for this presentation, it's really about the GDPR. Okay, so you must vet them, and you must go through a process of vendor assessment and vendor management. Larger organisations like MailChimp, will probably have signed up to the GDPR, and you'll find statements of compliance within their website. I can't say for definite with MailChimp, but have a look at that as an option. And if not, you may need to go and find other suppliers. Okay. Okay. Yeah. Another question here about legitimate interest. Tim, you are right. There is legitimate interest under the new e-privacy directive, but e-privacy isn't live yet. And I think that's one of those areas where marketers are definitely saying that the existing PECR and GDPR, for example, are loggerheads. Okay, there is no soft opt-in if you're collecting personal data for European residents, unfortunately. So my advice would be err on the side of caution there. E-privacy regulations don't have the teeth that GDPR do, so I would err on the caution in terms of making sure that you're compliant with the GDPR and seek active consent from your market, from those you want to market to. All of that said, I think the engagement levels with people who have opted in is likely to be higher as well. So you may actually find that that it works well for you, even though you've probably got a large list that is that demonstrates legitimate interest. For those who have already been receiving emails and haven't opted out, there is an argument there, and I have heard others make this argument that people have opted in and remain opted in. I think there's a fairly good argument for that, particularly if you've been mailing them for a while before the GDPR is in place. But I would definitely err on the side of caution if you're in any doubt. Okay, so if you're unsure whether you've got the right to email these people and you're only emailing them once a year, then it may be time to drop them an email and make sure that that you've got their consent. But be aware of the slide where I put up the details about Flybe and Honda got fined because they were actively marketing or actively emailing people who had said that they didn't want to receive emails. Okay, one more question. Unfortunately, I have got more than one question remaining. So what I will do is I will include answers to some of those other questions in the podcast version of this. So I'll just cover off this one more of one of these questions here. So what about an example of a recent data breach? Some of the really big ones, they've lost lots of data. What would the cost of, or what would the fines be? I think the person's asking here, what would the fines be under GDPR? It's difficult to say with absolute certainty. One example that we can draw upon was the TalkTalk example. TalkTalk were fined £400,000 for their data breach. Some of you may remember, particularly if you're based in the UK. Now, £400,000 is 4/5 of the maximum under the Data Protection Act. So, would they have got fined 4/5 of the maximum under GDPR? I can't say with absolute certainty, of course, but you can certainly see that they might have been fined several £million instead of the £400,000 they were fined in this case. Well, I hope this has been an interesting webinar for you. I like to try and keep them on time, even though I was a couple of minutes late, so I know that people will start to drop off in the next couple of minutes. If you've enjoyed the webinar, please do pass on the details to your colleagues. You will receive an email over the next couple of days about how you can listen again, either as a podcast or on YouTube. I've also written a book about GDPR. It's a general book, and I aim to create more a sense of this is just something that the organisation can deal with. It's not as big and scary as some organisations like to make out. Particularly, you'll see those people saying a lot on GDPR about how scary it is. And if you are interested in GDPR and learning more about GDPR, subscribe to the Fifth Step podcast and come and visit our blog. I write, and as do others, on GDPR and other subjects. Thank you very much for your attention today. Please do reach out if you've got further questions. I'm more than happy to answer those where I can. And Tim, a specific invitation to you and anyone else on the webinar. If I've not answered your question, or indeed I've not answered it fully enough and you want to get into some more of the details, then please do feel free to drop me an email. My contact details are there, and you can reach me on LinkedIn as well. Thank you very much for your time today, and I hope to speak to you again soon.